guys on strike?
Oh, we are an environmental pressure group of over 400,000 supporters.
Yes, and we are against the decision made by the Inspectorate of Pollution to build a nuclear plant in our area.
Your situation is similar with the case of Crown and Secretary of State for the Environment ex parte Greenpeace Limited, where the court held that the pressure group Greenpeace Limited did have a local standard to apply for judicial review due to its membership in the area as well as its access to expert information.
What is judicial review?
Judicial review is a court proceeding in which the lawfulness of a decision or action made by a public body is reviewed by the judge. In other words, judicial review is a process which judiciary review the actions of executive and legislative. Judicial review is one of the ways to checks and balance in the separation of powers, which means if the legislative and executive branches exceed their authority, then judiciary has the power to supervise the legislative and executive branches. It is not really important with the results of that process, as long as the law has been correctly applied and the procedures is correct. The court will not substitute what it thinks is the correct decision. This may mean that the public body will be able to make the same decision again so long as it does so in a lawful way. A person can bring an action under judicial review against the public body if the exercise of power is unlawful. If the court finds the exercise of power is unlawful, it may have squashed and possibly award damages or may impose an injunction to the public body. For example, in the case of Council of Civil Service Union and Minister for the Civil Service, the employee of the government communication headquarters are banned by the government from joining any trade unions for national security reason by an order in council using the royal prerogative. Then, the council take action under judicial review. The House of Lords held that the exercise of the royal prerogative was subject to judicial review. Next, I would like to talk about the procedure of judicial review. The procedure of judicial review consists of 3 stages, which is the pre-action stage, the permission stage, and the final hearing. First, the pre-action stage is that the claimant will write a letter before claim for judicial review to the public body. The letter explains the details on where the public body has gone wrong and how to make it right. If there is no satisfactory response to the letter before claim, the claimant can make an application for permission to bring a judicial review claim against the public body during the permission stage. Then, the judge will decide whether to grant permission to proceed to a full hearing according to the grounds of the case. If permission is granted to bring a claim for judicial review, then the case will proceed to the final hearing. In the final hearing, the judge will make the decision, and once judgment is given, then both sides can make representations about costs. Usually, the loser pays the winner costs. Judicial review is an important legal mechanism in upholding the rule of law, particularly the first and second postulate, which are to ensure that the government exercise their power within the legal authority, as well as safeguarding equality before the law. However, in reality, there are certain limitations to the application of judicial review, particularly the rules of local standard which will be discussed further in our presentation.
Who can apply for judicial review? According to Section 31, subsection 3 of the Senior Court Act 1981, the court must not grant leave for an application for judicial review unless the applicant has sufficient interest or formerly known as locus standi in the matter. From the constitutional perspective, the test can ensure that the person who applied for judicial review was not a mere busybody. There are three types of tests to determine whether the applicant has sufficient interest in the subject matter, namely the sufficient interest test, the victim test, and also the person aggrieved test. First of all, the test of sufficient interest was provided in the case of R and Inland Revenue Commissioners ex parte National Federation of Self-Employed and Small Business. The Federation saw a declaration that the Inland Revenue had acted unlawfully when they decided not to investigate the areas of unpaid tax by the casual print workers if they register in the future. This was totally different from the way the revenue treated other self-employed and small business people. However, the House of Lords held that the Federation did not have locus standi to challenge the revenue decision with regard to another group of taxpayers. To examine whether there is standing, a two-stage test will be involved. At the first stage, we should consider standing when seeking for an application for judicial review. In this stage, the court is concerned to ensure that it prevents busybodies, cranks, and other mischief makers. Moving to the second stage, at the full hearing, the sufficiency of the applicant's interest will be evaluated against the factual background to the application. Furthermore, the applicant for judicial review can be divided into three groups. Firstly, the applicant may be an individual whose personal rights have been affected by a decision. Secondly, the person seeking for judicial review in the defense of a group's own interest. And lastly, the applicant for judicial review may be a group acting in the public interest. Following by the sufficient interest test, the Human Rights Act 1998 introduced a new basis for standing. Section 7 of the Act states that only a victim of an act of a public body may make a claim. Article 34 of the European Court of Human Rights provides that the court may receive applications from any person, non-governmental organization, or groups of individuals claiming to be the victim of a violation, be one of the high contracting parties of the rights set forth in the Convention or the Protocols thereto. Therefore, we can see that the European Court of Human Rights has applied the same test with the Human Rights Act 1998. Thus, the applicant must be able to illustrate that they have been directly affected in order to bring a claim under the HRA. Furthermore, the victim test is narrower than a standing in other judicial review proceedings. The person aggrieved test was established under Section 228, subsection 1 of the Town and Country Planning Act 1990. It states that if any person is aggrieved by any action on the part of the Secretary of State to which this section applies and wishes to question the validity of that action on the ground that the action is not within the powers of this Act or that any of the relevant requirements have not been complied with in relation to the action, he may make an application to the High Court under this section. In other words, the general principle of judicial review applies to a challenge under Section 228 of the Act. Therefore, the applicant must prove two things. Firstly, the Secretary of the State had acted irrationally or misdirected himself in law or even failed to have regard to the relevant considerations. Secondly, there are some procedural impropriety. Next, I will now pass the floor to Nessa.
Now, I will elaborate on how the sufficient interest test broadens the availability of judicial review in two ways. Firstly, given that the issue of standing is not considered in depth as a preliminary matter during the first stage, the result of this more generous approach is that less cases will fail at this stage. In other words, more leave to application for judicial review will be granted, even though the case may still fail at the second stage when it is considered in the context of legal and factual of the case. Secondly, following the more open approach adopted by Lord Deplock in the Inland Revenue Commissioner case, the courts have since then taken an increasingly liberal approach towards the sufficient interest test. Sufficiency of interest will arise as long as there is a need to prevent governmental illegality, and it does not matter whether or not who is the corresponding applicant, so long as the case is being brought to the court. This means that personal interest in the matters is no longer required. Thus, the sufficient interest test allows representative standing to a certain extent, meaning actions can be taken by groups which are not necessarily directly affected but are concerned about administrative decisions, so long as the matter is a matter of public interest. This principle is illustrated in the case of R and Secretary of State for Foreign and Commonwealth Affairs ex parte World Development Movement Limited. The court granted the leave for judicial review to the applicant, which is a non-partisan pressure group, despite the fact that none of its members have a personal interest in the matter. In this case, the Foreign Secretary made a payment of aid to the Malaysian government towards a construction of a dam. The pressure group successfully challenged the decision. Rose Lord Justice pointed out that it is important to allow the application because otherwise the issue will be likely to escape judicial attention, given that there is no other responsible challengers. Besides, the application is also important to vindicate the rule of law. Furthermore, in the case of R. Corners House Research and Director of the Serious Fraud Office, two charitable organizations successfully challenged the decision made by the Serious Fraud Office, which is to stop the investigation into the allegations of bribery with regards to the arms contract entered into with Saudi Arabia. Although the claim failed on other grounds, the fact that local standby has been granted to two charitable organizations helps to preserve the rule of law, as it enables the public to scrutinize the arbitrary powers of the executive. On top of that, in the case of R and Secretary of State for Employment, ex parte Equal Opportunities Commissions, the EOC was held to have sufficient standing by virtue of its statutory powers to challenge the compatibility of the Employment Protection Consolidation Act 1978 with EU law. Lord Keith held that it would be a retrograde step if the Commission was given no local standby, given that the issue at hand concerns sex discrimination, which are of public importance and affect a large section of the population. The more liberal approach has also been applied to an individual in R. Edwards and Environment Agency, where the applicant, despite not having been active in the campaign, was still held to have sufficient interest to challenge the decision made by the Environment Agency to grant the permit to a company to burn waste tire as fuel, mainly because of the fact that he has interest in its outcome since he is an inhabitant in the area.
However, the problem of the sufficient interest test also limits the availability of judicial review. First of all, in dealing with such issues, the court is often perfunctory and not united in their decisions of the test as they take different factors into their consideration. As a result, the court is given great discretion in determining whether the applicant has the right of local standby in bringing the action under judicial review. For example, in the case of RN Secretary of State for Environment ex parte Rose Theatre Trust Limited Company, the issue is whether the company can bring an action under judicial review in campaigning to rescue the historic Glove Theatre site in London. Firstly, a direct financial and legal financial interest will not necessarily suffice the sufficient interest test. Secondly, a great quantity of people in joining the campaign will not necessarily suffice the sufficient interest test too. However, in the case of R.M. Borough Council ex parte BB, the court ruled that two pressure groups, the WWF and BHS, had sufficient interest to give objection to the decision of the council, which had granted planning permission to itself for the development of a heathland, as BHS had a financial interest in the site and WWF had undertaken to pay any legal costs if necessary. Hence, it is explicit that the approach taken by the courts in the case varies in the guidelines laid down in the case of R.N. Secretary of States for the Environment ex parte Rose Theatre Trust Limited Company. This shows the inconsistency of the courts in determining the issues of granting the local standard. As a result, it discouraged the bringing of action under judicial review since people are confused and unsure if they possess the rights of standing in bringing the action to the court. Secondly, the factors that the court put into consideration in granting the local standard often leads to limitation. A claimant will normally be granted to public interest standing only the application relates to public interest and the claimant is acting as a virtuous citizen would by bringing the application. In regards to public interest, it can be seen that the public interests in an overall sense are generally prioritized as a determining factor. Consequently, this widely limits the access to judicial review. As mentioned by Adam Perry in the Journal of Civic Virtue, the court should examine in the public interest is implicated in a matter instead of considering whether the outcome of the case could be beneficial in terms of public interest. Next, the intention of the claimant often is put into court's consideration in granting the standing. For example, in the case of R.N. Secretary of States for Foreign and Commonwealth Affairs ex parte Rees-Mogg. In this case, the applicant sought judicial review for the government's ratifications of Treaty on EU without Parliament's consent. However, the court held that Rees-Mogg has sufficient standing as he is sincerely concerned about constitutional issue. Whereas, in the case of R.N. Somerset County Council and ARC Southern Limited ex parte Dixon, stressed that the court's sole concern is that such application is not made by ill intention. Such considerations of the applicant's intention in one way or another will bring down the number of the occasions when the courts are able to determine if the public body's action was unlawful. To summarize, there are two main flaws of the sufficient interest test that leads to the acknowledgement of the accuracy of the statement which asserted by Lord Diplock. First is the lack of unity approach in providing the local standard. Secondly, is the rigidity of the factors which are put into consideration by the courts limits availability to challenge the public bodies by way of judicial review. And now, I will pass my floor to Taisia.
Human Rights Act (HRA) 1998 provides alternative routes to the application of judicial review. HRA is consistent with the procedural requirements of the European Convention on Human Rights, which means only victims of a public body's unlawful act may apply for judicial review in relation to human rights claims. It was stipulated in Section 7, subsection 7 that a person is a victim of an unlawful act only he would be a victim for the purposes of Article 34 of ECHR. Thus, the definition of victim under ECHR is incorporated into the HRA. On top of that, as the courts are also part of the public bodies based on Section 6A of the HRA, they are also obliged to act in accordance with convention rights. Hence, the rules of granting local standard to a victim of an unlawful act is strictly followed by the courts. Nevertheless, the victim test under the Human Rights Act is narrower than the sufficient interest test. Under victim test, a person is a victim only if he is affected by the measure in question. Next, we can refer to the case Ahmad G Limited and Mibek Kishvili and Georgia. In this case, the first applicant was a limited liability company which entered into a contractual relationship with Georgia Ministry of Defense, whereas the second applicant was the director of the company. The company had obtained an enforceable judgment from Ministry of Defense, but it was not enforceable for more than 5 years. The application of the company was granted under Article 6 and Article 1, Protocol 1 of ECHR. However, the director of the company was inadmissible because he had not been affected, thus he could not claim to be a victim. Thus, it is submitted that if convention rights of a legal entity, an organization or individual have been violated, the members of the board or shareholders are not automatically being considered as victims under this test. It will be justified only under exceptional circumstances to disregard a company's legal personality as being the person affected by the action or omission in issue. Furthermore, it can be seen from the case Dutton and United Kingdom. The applicant, who was a gay activist, had rights to private and family life. It means that by virtue of his claim being admitted to ECHR, it is clear that he fulfilled the victim test as he was a direct victim for the interrogation regarding his sexual activities. Besides, he also has sufficient interest as both a homosexual individual and a gay activist. However, if an organization or individual would like to bring the case on behalf of the applicant, it seems unlikely that they will be granted the standing. This shows the great limitation and restriction of this test in bringing the case under judicial review. However, it is submitted that the stance of victim test in Human Rights Act is very limited and restrictive. For instance, the victim test was found to be problematic in the context of domestic violence. It is mainly because the issue of domestic violence constitutes an unseen crime. Furthermore, the victims are too intimidated to lodge police report. They may also wish to take matters no further, even if they do report incidents. Thus, there are high chances that victims may not want to engage in litigation. Hence, the victim test is said to be problematic in dealing with the issue of domestic violence. Therefore, it is clear that victim test does limit the ability of judicial review, but it is restrictive and problematic due to some circumstances, even though the victim test can be categorized in 3 different forms, which are direct victim, indirect victim, and potential victim.
The reform of the standing doctrine was something that was considered to be fairly controversial. The reason being because allowing a claim for judicial review, even when direct and tangible interest was absent, was considered to be too wide, as it was sometimes misused for publicity purposes or deliberate delay. The general rule is that in order to bring a claim for judicial review, there must be sufficient interest. However, now the courts have adopted a more liberal approach. This being that the requirement of personal interest is no longer necessary. Hence, only the application by a perceived busybody or meddler will be rejected on standing grounds. Now, let's talk about how public interest standing can be improved. When it comes to assessing the civic virtue of an individual, the amount of emphasis placed on factors such as eminence and respect should take into account individual circumstances as well. Why? Firstly, it's because such factors have been correctly criticized as being elitist. The reason behind this is that it is an unfair burden placed on the poor and the poorly connected, whose virtues would be based on societal perceptions of their virtues and not what their inherent values and beliefs actually are. The reverse is also true when it comes to wealthy, well-known claimants. Such circumstances suggest that the courts should scrutinize assertions regarding expertise, motives, and public spiritedness. Despite all the reforms and suggested reforms of the standing doctrine, it is still important for us to take into consideration alternative models available in other international sources. For example, the American Convention of Human Rights. Here, we do not have the requirement of the individual being a victim. Secondly, we can also look at India. Here, the Supreme Court held that interest groups can take social action litigations when it comes to human rights victims of violence, especially those who lack resources, assertiveness, and those who are perhaps poor as well. And thirdly, we also have the optional protocol of the United Nations Convention. Here, the victim themselves can bring an action, or an individual can also communicate the violence on behalf of the individual or a group of individuals. Now let's talk about standing and the rule of law. Although standing does uphold rule of law to a certain extent, it also undermines two essential elements of the rule of law, that is, universality of the law and equality before the law. The rationale behind the standing doctrine is that in the absence of a competent claimant, the government or governmental bodies may contravene with their legal limits, and in this instance, the courts are powerless to intervene. Hence, we can see that this puts the government in a privileged position, and that is fairly contradictory to there being equality before the law. It should be noted that every citizen has an interest to be governed by the law, and this principle should not be departed from unless there is a reasonable, overriding public interest that requires withholding access to the courts. Although it can be agreed that allowing a case to proceed in some instances may be detrimental to the administration itself, the court already is protected by procedural rules, that is, to deny leave altogether or to refuse a remedy. Hence, it can also be argued that the standing doctrine can adequately be satisfied by resorting to procedural rules. The court should also recognize that a bona fide litigant with an arguable case, one that is not vexatious, frivolous, nor an abuse of the court process, should not be denied standing, especially if they are sufficiently informed on how to effectively challenge an adversarial system. It is also important to note that there are other limitations to judicial review, even when standing is present. This includes justiciability and ouster clauses. The former suggests that when a complaint involves matter of public policy, then it is solely left to the resolution of the executive, not the judiciary. The latter suggests that in an attempt to exclude judicial review, whereby the error is made within the court's jurisdiction, then the court is deprived of this jurisdiction, thus giving effect to the ouster clause. Hence, when it comes to the question on whether or not standing doctrine actually limits judicial review, we say yes, but only to a certain extent, for all the reasons we have stated in this video.